The matter before the court is York 23413, Metropolitan Property and Casualty versus Susan McCarthy et al. We are being streamed live on the web, both by audio and visual. And if counsel who are arguing would identify yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
Good morning, Your Honor. Steve Segal on behalf of the appellant, Susan McCarthy. I'm also joined by my colleague, Michael Donlin.
Jeffrey Edwards for appellee, Metropolitan Property and Casualty Insurance Company.
Thank you. And Mr. Segal, if you're ready to proceed, we'd be happy to hear your argument.
May it please the court, again, my name is Steve Segal, and I'm here today on behalf of the appellant, Susan McCarthy. Your Honors, there's no doubt that parties have spilled a lot of ink on the paper, both in briefings and in the trial court below. And there's also been a long procedural history in this case, covering multiple forums. But the bottom line is this: in terms of where we are today, this case is all about you. That is, whether Metropolitan's use of the term you in two exclusions under its policy operates to bar coverage for the negligent acts of its insureds, the McCormicks, due to the fact that another co-insured, ZC, committed acts that fell within the exclusions for intentional acts and abuse. In other words, does you in these two exclusions mean the insured or any insured? The trial court found that there would be coverage under the policy unless an exclusion applied, because McCarthy established at trial that there was a bodily injury arising from an occurrence as those terms are defined in the policy. Metropolitan did not challenge that finding post-trial nor appeal it before Your Honors. Notwithstanding that finding, the trial court also concluded that coverage was barred by the intentional loss and abuse exclusions. We respectfully submit that the trial court erred in finding that these exclusions applied to the negligent insureds for four primary reasons, any one of which is sufficient to find in McCarthy's favor. First, by applying you to the McCormicks, the negligent actors, as that term is used in the two exclusions, the court improperly applied an expansive reading of the exclusions rather than a narrow construction as required under Maine law. Second, by ignoring the fact that Metropolitan knew how to and did expand the meaning of you in other parts of the policy, thereby demonstrating that the term was not intended to be as expansive in the exclusions at issue in this case. Third, by failing to interpret—
Green light's on. Didn't quite get through all four.
That's all right, Your Honor.
I want to get my head around the precedent. There's no published case in Maine that deals exactly with the language of these exclusions, correct?
I agree with you.
So let's look outside Maine. Metropolitan, as I've understood it, found two unpublished New York decisions, exactly the language that are against you. What case uses exactly the same language and supports your position?
So, Your Honor, on a couple of points. So I assume you're talking about the Roddick and Colmy cases out of New York. Mm-hmm. Significantly from McCarthy's standpoint is those decisions derived from an unopposed briefing.
Right. I get why you want to distinguish them, but what case anywhere supports your position based on the exact language of these exclusions?
Sure. In terms of where you is at issue, and I assume that's where you're going, Your Honor.
Well, in any, and then the definition.
Sure. So, I mean, the framework, as I see it, really comes from Johnson and Crocker, which this court has decided, right? So even if, and I understand it, there's no the insured or any insured in this precise policy, but that is the framework that this court needs to decide, respectfully, is whether by use of the term you, are we talking about the insured, like in Crocker, or are we talking about any insured, like in Johnson, with the idea being, right?
But isn't that answered by the terms of the policy? I mean, the policy itself defines you to mean the person or persons named in the declarations, and if resident of the same household, spouse, relatives, any other person under the age of 21. I mean, isn't it answered by the policy? I understand it's a different word than the insured, but isn't it really just a proxy for that as defined in the policy?
So with respect to the definition, Your Honor, just to be clear, you probably already appreciate this, no dispute from our side that the McCormicks fall into the definition of you that you just identified, right? We don't dispute that. But in terms of then looking at the word you as used in the exclusions, there's no indicator, unlike Johnson and Crocker, where you had words like any in front of insured or the in front of insured. There's nothing like a you or any you or the you.
But the
why should
plain
there-
language of the provision that I think we're talking about, in the event of such loss, in this case the loss is the sexual and physical abuse, in the event of such loss, no one defined as you or your is entitled to coverage, even people defined as you who did not commit the action causing the loss.
So respectfully, Your Honor, and I may be misreading, there's an intentional loss, there's a parallel intentional loss provision in a property loss exclusion that talks about no one defined as you would get coverage.
Yes, and that's what I'm reading from.
Oh, okay. Well, on that, that's actually not the one that's at issue in this case. That one's a parallel provision for what we say expanded the definition of you, meaning Metropolitan knew how to expand the definition of you, and notwithstanding its current position, it knew that by just saying you.
So by putting it into the property loss section, referring to you in that context, but not doing so in the tort side of it, is a significant fact that we should consider to say that it doesn't apply, doesn't extend?
Absolutely. That Metropolitan understood that by just saying the word you in the exclusions at issue here, it knew, notwithstanding its position now, that it would not cover every insured if one insured was triggered, right? In the one you just cited, Your Honor, that the point there is they knew they had to expand it, otherwise it would only apply to the you that did an intentional act.
Why would there be a distinction there? I mean, in this, as you know, there's a body of law about extending coverage for intentional acts, particularly sexually abuse of minors, that sort of thing. And the companies are aware of that, and they don't want to cover it. And why would they conceivably not wrap that into the fact, this overarching exclusion for intentional acts, but specifically physical sexual abuse? I mean, that doesn't stand to reason. Are you saying you're parsing the language and that's as far as you're looking?
Well, I guess what I'm saying is, one, I don't know why Metropolitan obviously wrote it the way it did, right? But with respect to, they had every opportunity. If they had said, instead of you, if they had said any insured or something along the lines of what was said in Johnson, I think that ends this dispute. But when it said you, again, in terms of a narrow construction of an exclusion, a narrow construction would be that just the you who committed the intentional act or the abuse would apply. Whereas if we did it the way the court did it, it's expansive and goes against Maine law. I think there's another point too here, Your Honors, is that arguably there's an ambiguity. From our position, it's clear that it only applies to the you who commits either the intentional acts or abuse.
But even if that's true, then don't you kick out under our case law that says, yes, but if the damage that was caused is the same damage. In other words, even though you're alleging independent negligence by McCarthy over the minor, the damage is the same damage.
No question the damage is the same damage.
But isn't that covered? In other words, even if we construe you narrowly, the damage is still the same damage.
I think, Your Honor, where we would respectfully submit we go is that in Crocker, you had that exact situation, right? So you had an intentional actor, and then you had the negligent actor, and the court found, look, yeah, there's not going to be coverage for the intentional actor, but by virtue of
in Crocker, we were construing the expected or intended, correct?
right, I think it was an intentional loss.
Which is a little bit different. And here what we're talking about is we've got two provisions, the intentional loss, but also the provision about with the abuse exclusion.
Agreed.
And that just says we do not cover bodily injury caused by or resulting from actual, alleged, or threatened sexual molestation or contact, et cetera. And it doesn't seem to really matter by whom it was inflicted.
So on that very issue, Your Honor, the next sentence, though, in the abuse exclusion says, this exclusion applies whether the bodily injury is inflicted by you or directed by you for another person. You may have noted that in our briefing there was some discussion about the First Circuit decision that issued back in, I'm doing this from memory, I think it was 2013, 2014, talking about there was an ambiguity there as to whether this applied only to any individual who committed abuse or the you who committed abuse, and said that at best, for Metropolitan, it was ambiguous, and therefore there needed to be some you in order to trigger that.
But that's why I'm questioning whether it really kicks back into the Johnston and Allsay, where it's the damage is the same regardless of how you define which is the you.
I gotcha. I hear you.
You don't agree?
But I think, and again, this was kind of the point I was trying to get, I think, to Justice Connors earlier, is that, at least based on the body of Maine law, I think the framework necessarily is Johnson or Crocker. And with Crocker being to what we were talking about a moment ago, Your Honor, that there still can be coverage even if the harm is exactly the same, if we apply it as the insured as being the equivalent for how you is being used in these exclusions.
I'd like to draw your attention to a policy provision. It's at page 106 of the appendix, and it's mentioned in the briefs. It addresses intentional loss, and I'll just read it. In the event of such loss, meaning intentional loss, no one defined as you or your is entitled to coverage, even people defined as you or your who did not commit or conspire to commit the act. And in this case, Ms. McCarthy, Susan McCarthy, is one of the people defined as you or your.
I'll back up just a second. She is an assignee to the original insured.
But she's claiming coverage.
Agreed.
And ZC is also within the scope of you or your. And doesn't that clause apply? The Chief Justice has pointed out that it refers to property loss, not personal injury. But you agree that, at least with respect to property loss, this clause would preclude recovery.
I think that's probably right, Your Honor, if that was the one that was at issue on this appeal.
Right.
From our perspective, it actually supports our position because it shows that Metropolitan knew how to expand the definition of you in certain situations.
With regard to property loss.
Correct. And the language that you cite here is noticeably missing in both the intentional loss for bodily injury and the abuse provision.
There is a sentence from Crocker that maybe is not, the case may not be analogous, but I think probably the Superior Court was leaning in the same direction. It says, such an insured language in an exclusion clause is equated with any insured, and means that the conduct of any insured that is excluded from coverage bars coverage for each insured under the policy. I mean, that's sort of a broad statement there, but that, again, I'm getting back to my point. Common sense would indicate, particularly if they're applying that to property loss, when you switch it over to an egregious intentional tort like physical abuse or sexual abuse, it just seems inconceivable that they would say, okay, we'll cover this for the person who actually did it, but if you're not you're a policyholder under the same policy, you don't get that same exclusion for that injury. It just seems that you're focusing more on that language as opposed to the risk that is insured. You see what I'm saying here, just philosophically?
Sure, Your Honor. I'm focusing on the language because I think that's exactly what we need to do in terms of what the court needs to do in terms of interpreting these provisions, including, we haven't really got into it, but interpreting it from an average person. I see the red lights on my.
Finish your answer.
Untrained in the law or insurance. And on that point, sure, if ZC looks at this, ZC knows he's a you, would understand these exclusions apply to him, but if the McCormicks, even understanding that they are a you as well, wouldn't think, well, because ZC is out, so to speak, we're out as well.
Thank you. Mr. Edwards.
May it please the court. It is the position of Appellee Metropolitan Property and Casualty Insurance Company that the judgment of the trial court should and must be affirmed. The trial court correctly determined that the bodily injury sustained by MCM are not covered by the Metropolitan policies issued to Glennis, Dixon, and McCormick as the named insured, based upon both the intentional loss exclusion. to
Mr.
the
Edwards, since the green light is on, I'm going to go there.
Okay.
We've already talked about the difference between the intentional loss exclusion for property damage versus for bodily injury. But it really seems quite clear under the exclusion at page 106 of the appendix that the intentional loss, it has a lovely statement that says, in the event of such loss, no one defined as you or your has coverage. It doesn't do that when we start talking about bodily injury. I mean, shouldn't we take that to mean then therefore it is not necessarily intended to be so broad?
Well, first of all, I mean, you is a defined term at the very beginning of the policy.
I made that point.
You is used throughout the policy. It's used in describing different coverages throughout the policy. The portion of the policy that the chief just referred to is a section in the property coverage of the policy, and basically it states that if a person within the definition of you, one of those four people or four categories of people commits arson, then nobody within the definition of you can recover a claim.
I understand that, but unlike the property damage, where it then goes on to try to make clear that we mean everybody, it's really quite curious at page 115, I think it's, what is it, page, 115 of the appendix, where it says, you know, we don't cover bodily injury, property damage reasonably expected or intended by you, assuming it to be as broadly defined, or which is the result of your intentional or criminal acts. But it goes on to say this exclusion is applicable even if, and it almost seems like it narrows it, like it's only considering, it applies regardless of whether you are actually charged or convicted. It applies even if you lack the mental capacity. I mean, it's very odd the way that it's quite different from the property damage.
Well, I mean, again, again, if we're talking about the exclusion for intentional loss, I mean, the sentence very clearly states that we do not cover, the policy does not cover bodily injury that is intended or expected by you. And you, again, the trial court below did not engage in any expansive interpretation of that definition. I mean, and it was basically stipulated that ZC was a you, and again, by the plain language of the intentional loss exclusion, there is no coverage available for the bodily injuries suffered by MCM by operation of the intentional loss exclusion, because
but the
a
plaintiff makes
person
a good
within the
point.
definition of you committed the acts.
We look at the insurance policies through the eyes of the average person reading it, and plaintiff makes a good point here. This is really written, the intentional loss is written in terms of the actor. When you read that, I think the common person would figure they're talking about the actor here.
Well, again, that's why insurance policies, Your Honor, have defined terms to avoid that problem of people interpreting the language in a common sense way. For example, occurrence is a defined term. Occurrence could mean to an average person something that happens, but it doesn't. It's a technical term, it's defined, and it means an accident. Bodily injury could mean something to the average person.
Well,
but,
is there any limitation on the exclusion with respect to abuse? It just simply says you, and you is a defined term in the policy, is it not?
Abuse is not defined.
No, you is a defined term
You
in
is
the
a
policy.
defined term.
There's no limitation on the use of the you definition in the context of the exclusion for abuse.
Yeah, the abuse exclusion applies to abuse inflicted or directed by anybody within the policy definition of you. And that's the way the policy is written. There's no exception to that. And again, the court below did not engage in any expansive interpretation of the policy definition of you in arriving at the conclusion that the abuse exclusion operated to exclude coverage for the bodily injury suffered by MCM.
But taking you back again to the property damage exclusion, the company takes pains there to say it doesn't only apply to the person who did this, but it also applies to someone who is an insured who actually didn't commit this act. It's a blanket thing. It covers them. It seems to be narrower on the abuse side. Just as I said before, someone looking at it would have to say, okay, you is covered. Let me go back to the definitions. Ooh, you is everybody who's insured.
Well, I mean, everybody who's within the definition of you.
Right.
Okay.
Yeah.
But again, I think the court has to keep in mind that what was going on here as it relates to the property insurance side, the Section 1 of the policy.
Yeah.
That policy is being drafted to deal what's known as the innocent co-insured doctrine. In other words, so that arson by anybody within the definition of you excludes coverage for anybody within the definition of you, even though you're an innocent you, okay? Same thing with fraud. Again, it deals with the innocent co-insured issue, namely fraud by anybody within the definition of you excludes coverage for anybody within the definition of you. And again, that's because on the property side, on the first party insurance side, on the homeowner's policy, there is that concept of the innocent co-insured that's in all the reported cases, but that's the method to the madness in terms of making that explicit distinction. And I would take the position that by adding that additional language, it's not changing the definition of you, it's just providing more of a clarification and explanation so that the policyholder reading the policy will realize that if anybody within the definition of you burns down the house, then I can't make an insurance claim.
Exactly. But do we take anything from the fact that they didn't feel it necessary to add what you're calling the clarification?
Well, because the innocent co-insured concept does not apply on the liability side.
Well, but does the presence of the innocent co-insured provision and the property loss provision create an ambiguity when it comes to the liability side?
No, it doesn't, because the policy is pretty clear and straightforward. It says that we do not cover bodily injury that is intended or expected by you. And you is a defined term, and very specifically defined.
And for property damage, it's the same, but yet there's this additional clarification that if you weren't involved in the property damage, you're still covered.
Well, I mean, again, I think it still stays the same thing. I mean, you could have rewritten the policy in the liability section to, if anybody, if you intend or expect bodily injury, then we do not cover it. I mean, it's just a matter of the way the policy is drafted. If you look at the intentional loss under the property section of the policy, it says the same thing. If a you burns down the house, then nobody within the definition of you has coverage. It doesn't really change the definition of you. It's just a matter of the way that particular coverage was drafted. But the word you is used consistently throughout the policy to refer to the categories of people who are described in that definition of you.
So what you're saying, in layman's terms, is that in the world of belt and suspenders, you definition is the belt. Maybe there are some suspenders in the property loss, which is adding to why they're not covered. But the belt is good enough because if you read the definition, it's unambiguous.
Yeah, and it's a simple, straightforward statement. You know, we do not cover bodily injury that's intended or expected by you. You is bolded in the policy. It's a defined term at the beginning of the policy, and it's a defined term because of the need to avoid the situation where what a common sense definition of the word you would be by an average insured.
Can I ask you a side issue, not necessarily raised by this case here, but the plaintiff in this instance is not suing, alleging an intentional act. The plaintiff is alleging a negligent act. In other words, the defendant here didn't commit any intentional assaults or sexual abuse, anything like that. Rather, it's an entirely different cause of action of negligent, I assume, negligent supervision. Does that allow them to sidestep the policy exclusion for intentional acts of abuse?
Well, no, Your Honor. I mean, and again, I mean, no one's contending that Glennis Dixon McCormick was a perpetrator.
Right, of course.
And again, this is a recurring fact pattern in these intentional loss cases. The party who negligently failed to prevent the perpetration of some evil deed. But in this situation, the way, again, the policy is drafted, it's intended to basically exclude the negligent failure to prevent the bodily injury.
So we focus on what is the occurrence here, what is the injury? The injury here is a subject matter that is excluded. Is that what you're saying?
Well, we do not cover bodily injury that's intended or expected by you, and that encompasses everybody in those 4 categories.
Of course.
I'm repeating myself, but it's made that way.
But Glynis didn't intend or know this was going to happen.
And that's the
Look,
reason for the narrative.
She did not intend or expect anything like this to happen, I suppose. I mean, we never got into that part of the case because the case was settled, but let's concede that for the sake of argument.
Okay.
But the point of the matter is bodily injury that's intended or expected by any person within the definition of you is excluded from coverage.
And it was Johnson said it's the nature of the injury as opposed to who expected it or intended it.
Exactly, right. And again, Johnson also, the Johnson case is as close a case as we have to this one in the sense that the Johnsons in that case, I think, were innocent co-insureds in the sense that they were negligent and they were not perpetrators.
Mr. Edwards, can I please go to finish the question I keep trying to ask, which is, let's go to Section 18 exclusion for abuse. First of all, is it your contention that either one would exclude coverage here?
Either one?
Yes.
But both do?
Yes. So in other words, even if we agreed somehow on the argument with regard to intentional loss, nonetheless, the abuse exclusion also excludes coverage in this case, correct?
Correct.
From your perspective. All right. So the abuse exclusion seems to say, again, we don't cover bodily injury caused by or resulting from various acts, and it seems to be without regard to by whom it was caused. Is that what you're arguing?
That would be my argument, and has been my argument since at least 2012, Your Honor, that the exclusion for abuse excludes all abuse regardless of the perpetrator or the persons involved. All abuse is excluded by the first sentence of the abuse exclusion.
Then what is the purpose of the second sentence?
Second sentence is clarification, once again, just to make it clear to people within the definition of you that this exclusion would apply to their conduct in abusing, causing bodily injury with resulting from abuse. So again, that those issues have been litigated to some extent in the past. It's referenced in the brief, but I would say, at least for purposes of today, it's pretty clear that the abuse exclusion certainly applies to abuse inflicted or directed by you. In other words, a person within the definition of you. But again, I would argue more broadly that abuse across the board by any perpetrator, whether or not they're within the definition of you, is excluded from coverage.
I guess that's my question. So you would suggest that this would exclude it regardless of who caused the injury?
Correct. But in this case, I mean,
contrary to what the First Circuit, how they interpreted this language.
well, the First Circuit and the U.S. District Court for the District of Maine.
It's a duty to defend, so it's a different level.
Exactly. I mean, that's, again, that's what we litigated at that level. Again, I'm not relitigating that. To some extent, it may be the law of this case, but certainly I still believe that the abuse exclusion as drafted excludes all abuse and is not limited to abuse perpetrated by an insured, by a you. But in any event, in this case, the abuse was perpetrated by a you, ZC.
Well, the complaint in this case alleges emotional injury as well as bodily injury, and the exclusion appears to apply only to bodily injury, which is defined to be physical harm.
Yeah.
So is there anything in the policy that excludes coverage for emotional injury caused by abuse?
Well, I mean, as a standalone exclusion, and I'm going a little bit from memory here, Your Honor, because I don't think this has been raised either before the trial court or in the briefs, but I believe that emotional distress arising out of bodily injury, physical harm, would probably be covered, but standalone emotional distress is not covered. But again, I'm not relying on the emotional distress exclusion to the coverage. We're relying on the intentional loss and the abuse exclusion. Thank you.
Thank you. Not sure whose phone was going off.
Your Honors, I just sat through hearing about Metropolitan's attempt to clarify the language. I know that's the language that's been responded to with respect to our arguments. I mean this with all due respect, and it's a rhetorical question, but how hard would it have been to say, if it was really supposed to be any insured, that they know that Johnson and Crocker exist. All you have to say is any insured in both the intentional loss exclusion, in the abuse exclusion, and that kills this issue, I think, probably, with all due respect. And with respect to the abuse language, it's their language. They didn't need to say the second sentence that said, this applies whether you intends to do it or you inflicted it. They could have just said, we're not going to cover abuse, period. But they didn't do that. They kept going. And this
Can
is
I
what the first...
stop you for a second?
Of course.
I mean, insured is not, unlike other policies, when it's used as an insured, they do not define an insured or any insured in this policy. They define you, and they seem to use you throughout the policy, or your, as a proxy for what would have been insured in older policies. Isn't that true?
I think you're probably right, Your Honor, from our perspective, the enormous caveat about whether is it any insured or the insured, and that's not clear. Well, from our perspective...
And that works with the word insured, but we don't usually say any you or the you.
I understand. And
Grammatically, we just don't do that.
And I don't mean to be a broken record here on this, Your Honor, but again, that's Metropolitan's language. They could have done exactly your point. They could have said any insured or the insured, but just didn't do that. One point Justice Connors raised I just wanted to address quickly if I can. In terms of what the First Circuit held, from our perspective, whether it's coming from a duty to defend window or a duty to indemnify window, it really was a contract interpretation in which they found this is just ambiguous. So from our position, whether you're in duty to defend or duty to indemnify, you get to the same conclusion.
Thank you.
Your Honors.
Well, thank you, counsel, for your arguments here this morning. And we will take this matter under advisement and issue a written decision in due course.